Hi, everyone. I'm Professor Christa Laser. I'm a law professor, a former big law intellectual property litigator, and now a scholar on law and technology. Today, we'll walk through some of the legal issues in artificial intelligence with a special focus on intellectual property law. There are legal risks that span the whole range of intellectual property law, from AI companies that may face billions or even up to $1 trillion of damages for using copyrighted works to train their large language models, to users who may unwittingly lose their copyright or their patent protection when they use AI to assist with the generation of creative works or inventions. I'm going to walk through a quick overview of each of these different areas of intellectual property law first, before we dive into how it affects artificial intelligence, because many people confuse these different areas. So I apologize if this is something that you all know already, but I'll keep this part quick. Copyright law protects original works of authorship that are fixed in a tangible medium of expression. This means that it's not just an idea, it's a writing, a photograph, a piece of code, something that is firm and fixed in its final expressive form. It lasts for the life of the author, plus 75 years, or 95 years for a corporate author. And it protects against the copying or the distribution of those creative works. It also protects against the creation of derivative works. That means remixes. And this comes into play a lot in the AI context, because the outputs of AI systems may still infringe a copyright, even though they're not identical to those underlying works, because they are unauthorized derivatives of those originals. Trademark is different. Trademark protects consumers against brand confusion and helps to ensure the quality is consistent across the same brand identity. A trademark can be a logo, it could be a brand, but it's anything that identifies the source of the goods or services. It could also include things like a smell or a sound, like "You've got mail" for AOL is a trademarked sound, or the pink color of insulation is a trademark color. Trademarks can last forever, as long as they're used in the marketplace and consumers associate those with a particular brand. Right of publicity protects the name, image, and likeness of a human person. This is a state law right that differs from state to state, but most states only provide protection against commercial uses of somebody's name, image, or likeness, not just merely unconsented uses. And because this differs from state to state, you may find that in some states, for example, a celebrity could die and no longer have their rights, their heirs would no longer have those rights, whereas in other states, that celebrity can pass on that right to their heirs. There's a lot of differences from state to state. Patents protect inventors who come up with new, non-obvious, and useful innovations. This is something where you're going to have to apply for protection with the patent office. It's an expensive and time-consuming process. But once you get through that, you get 20 years of market exclusivity. It prevents anyone else from making, using, selling, importing anything that aligns with the claims of your patent. Trade secret can be useful for anything that's not protected by the other categories. Trade secret law is available to protect anything that is commercially valuable because of its secrecy and maintained as a secret. You have to take efforts such as signing NDAs or maintaining badging procedures to protect that. And it only protects against theft and misappropriation. It doesn't protect against independent creation or reverse engineering. So let's dive into what each of these areas mean in the context of AI. We'll start with copyright, because that's the one that could likely be putting some of these companies in $1 trillion of damages. 2 early case decisions have come out so far, and they conflict over whether it's a fair use to train AI models on copyrighted material. Fair use is a defense to copyright infringement. And if you are found to be acting with fair use, you're not liable for any damages for that copyright violation. This early case law also conflicts over whether it's okay to use pirated data as the source material for those LLMs. The key cases that we'll go over were decided last month: Bartz versus Anthropic and Kadri versus Meta. These cases are likely going to go to the Supreme Court within about 5 to 10 years, and there are over 30 other cases currently pending against a variety of other AI companies and brought by a variety of other creatives. To start with the Bartz versus Anthropic case. In Bartz versus Anthropic, book authors sued Anthropic for using copyrighted books to train their AI model. Some of Anthropic's data set included lawfully purchased books. One thing that Anthropic did was they went to publishers and they bought copies of their used books. They went to bookstores, they paid $1 or $2 for those used copies, and then they digitized them, scanned them in, and they actually tossed the physical copies. So they only maintained that digital version of a lawfully purchased item. The judge said that's totally fine, right? You can imagine that's fine because you're paying for what you're getting. But if you register your works with the Copyright Office, as almost all publishers do, then the damages are a statutory range from $750 up to, in the case of willful infringement, meaning you intended or knew that this was pirated, as Anthropic did, it appears in the data here, that it can go up to $150,000 per work. So the previous largest judgment in history was $1 billion against Cox Communication for infringing 10,000 works. If you take $750 to $150,000 and multiply it out by the 7 million works that are infringed here, Anthropic could be facing a range of $2 to $5 billion at the low end of the range to $1 trillion of damages at the high end of the range. Most commentators suspect that, and ultimately this will be decided by a jury. They're going to decide how guilty is Anthropic, and that will determine the range that it falls within that. Most commentators think that we're likely going to see a damages judgment of around $25 billion. But you can imagine that if an action of 10,000 works resulted in an award of $1 billion, we'll probably be seeing a lot higher numbers for these AI training models. So that tells you if you are using AI models, if you're training AI models, you need to buy the works that you're going to be using for those training libraries. However, we have other case law as well, coming out surprisingly from the same court, a different judge on the same court. This is in the Northern District of California. It handles cases coming out of San Francisco. Most of the AI cases are there. Some of them are in New York. So therefore, that's not protectable, and it is public domain. I don't know if you guys had heard that at one point they found that a monkey taking a selfie was a public domain work. The same thing applies here. Any non-human creator is not entitled to copyright protection, and it becomes public domain. Same is true of AI works. After that, the Copyright Office had a round of rulemaking where they heard some feedback from folks in the community. They adjusted their position a small amount, but they still maintain that AI-generated works are not protectable. They noted that using AI to edit a human work might be okay, but you have to disclaim every portion that was AI generated. So you have to keep track. What this means is that under current Copyright Office policy, you have to keep track of every component of your work that resulted from AI generation, and when you apply for your copyright, disclaim that portion. The Copyright Office said that selection and arrangement of AI works can be protectable, but that doesn't protect the underlying AI portion. So a corollary to this is recipes. Recipe books are protectable as a collection, but recipes are not protectable. So if you have a cookbook, you can prevent somebody from copying your whole cookbook because that's an arrangement and selection of unprotectable material. But if somebody copies a recipe out of your book, you can't do anything about it. It's public domain. It's not creative. It's not protectable. That's the same approach that the Copyright Office is taking to AI-generated works. So you can make a book that has AI-generated components, but if someone takes a chapter that was written by AI, no recourse. It's public domain. This was an example actually by the same author of Zarya of the Dawn, created a test case. And they tried starting with a human creation, a human sketch, and asked AI to enhance it, and then asked the Copyright Office to register this as a test case. The Copyright Office said that you have to disclaim all the AI-generated portions. So effectively, the only part of this that's protectable is the original sketch and the portions of the output that are identical to the original sketch. All of the three-dimensional imagery, the detail in the roses, all of that is unprotectable because that's AI-generated, not human-generated. So what does this mean for people in software or in tech? Vibe-coded apps, not protectable. Decks and marketing generated with AI, not protectable. Books and entertainment that are used with AI components, those AI components need to be disclaimed. So how do you manage this risk? You need to understand the potential risk of loss of your rights and establish policies to make sure that you're protecting against risk to your clients. You don't allow your employees and your contractors to use AI for things that are critical to have intellectual property protection, for example, in the entertainment industry. This could change, but it might take 15 years. We saw this play out in the case of the photograph. Originally, the Copyright Office said that photographs were not protectable because they were not the product of human expression. They were machine expression. This was in the 1800s, and it took about 15 years to get up to the Supreme Court. And eventually, the Supreme Court held that this photograph of Oscar Wilde was, in fact, protectable creative expression. The court found that even though the photographer was using a machine to generate this work, that machine was controlled by human creativity, and the output was a result of human expression. I think it's likely that the court will find the same with AI, but in the meantime, we're going to face about 15 years of denials of copyright registrations. There's also risk to users of AI in other ways. So users of AI can be liable for copyright violations in the output of the AI. If you prompt ChatGPT to create an image that contains a Disney character, and then you publish that on your social media, you're infringing Disney's copyright. Characters are copyrighted and they're protectable in that way. I will say with the exception of Steamboat Willie, which has now come out of copyright. But most Disney characters, this is going to be a problem. If your output has a storyline that matches a famous movie, that's going to be problematic. Or if your output has a New York Times article. All right, let's switch to Trademark. Trademark. You can use AI to generate a trademark. You won't risk loss of your trademark rights if you use AI to create your logo or to make a cool brand name. However, you need to do some things to make sure that you're still keeping yourself protected and free from risk. One of those is after you get that AI-generated logo or brand name, you need to run it through a search of existing products and make sure that it doesn't conflict with those products or create potential consumer confusion between an existing brand. Simply because the AI generated it doesn't mean that you're free to use it in the marketplace. You need to go run a check for that, because you could face liability for trademark infringement if you use those works. Another one is never use AI for product photos. Never. I know this is something that people may be surprised by, but you can run into false advertising risk and fraud on the Trademark Office risk when you use AI to generate product photos. Why is this? I'll look at this example here. We have a prompt. Apply our brand name to a beautiful photograph of a glass bottle with green liquid against a backdrop of tropical leaves. In that case, you're putting your name of your brand on a product that you didn't create and that you're not selling in the marketplace. When you do that, and then you submit that, for example, to the Trademark Office, you're telling the Trademark Office that you're actually selling that in the marketplace. You can't get a trademark under most categories of trademark protection. There are some exceptions for if you're about to use it in 6 months, but for most of the situations, you cannot get a trademark if you haven't used it in commerce. And that means you have to actually use that logo on a product that's physically standing out there. You know, you have this logo on the bottle, on the product that you're selling in the real world. If you do that with AI, you could face problems. And if you commit fraud on the Trademark Office, you can lose your trademark rights. Right of publicity. So we talked about name, image, and likeness rights. One interesting recent case that came up was Scarlett Johansson. Scarlett Johansson was concerned because OpenAI used a sound-alike voice to Scarlett Johansson to create the voice of Sky, one of AI's voices. Now, OpenAI had repeatedly asked her during the course of development, including a few days before it was released, whether they could have permission to use her likeness, her sound likeness, for that voice. And she kept saying no. And then when this came out, that they were about to launch a voice that sounded like her, everyone pointed out, hey, this is a really clear right of publicity violation because sound-alikes are an infringement of right of publicity. So they pulled that voice, and she never ended up suing. But if they had used that voice, she would have had one of the clearest cases of right of publicity violations that you can imagine. A previous case of this came up in the 90s with Vanna White. She sued Samsung for using her likeness, a robot likeness of her, in an advertisement. And she got an award of $400,000 for use of her likeness in that advertisement. Right of publicity protects against commercial misappropriation, varies state to state. And we have seen that some AI models are potentially going to be liable for right of publicity violations for using images of real people, such as in YouTube videos, for their training. Those cases are proceeding. They passed the motion to dismiss phase in cases in New York. Well, we'll see what happens with those. You can use contract law to get around the murkiness of this state-by-state right of publicity violation problem. The SAG-AFTRA contract gave union actors key contractual protections, meaning that instead of going through right of publicity law on the state level, you can also bring a case for contract violations, which is much more clear and easy to establish. This contract requires consent before the creation of digital replicas, requires compensation according to what the value of that person's actual in-person work would be, and makes sure that the person who's depicted has control over how their image is being used in a movie. For example, you can't hire somebody as an extra, scan them in, and then all of a sudden slot them in as a main character without their consent. And if you do slot them in with their consent, you have to pay them as a main character. You can't pay them as the extra. This was extended to video game actors a few weeks ago. Non-union actors don't get the benefit of this contractual provision. Deepfakes is another problem with right of publicity. In 2024, deepfake pornographic images of Taylor Swift went viral on Twitter with 45 million views in only 17 hours. The account was eventually suspended, but obviously this causes deep emotional harm to the people that are involved. 90 to 95% of online deepfakes are used for non-consensual pornography. And typically there's no recourse for this under state right of publicity law. That's because, remember, most state right of publicity law requires that the use be commercial. And most deepfake pornography is put online for free. As a result, Congress recently passed the Take It Down Act. This provides a federal protection in a very narrow circumstance. Specifically, it criminalizes distribution of non-consensual intimate imagery, including deepfakes, with enhanced protection for minors. And it also makes sure that platforms have an obligation to remove that content when it's flagged. And it's a 48-hour takedown requirement. If they don't take down the content within 48 hours, the platform that hosts the content can be liable for that content. And when you're talking about something like images of minors, there are heavy criminal violations associated with that the platform could be liable for if they fail to remove the content. All right, let's talk about patents. Eligibility for AI inventions. We have a similar problem as we have in copyright law. If you use AI to create an invention, you may lose your rights. It's not quite as severe as it is under the Copyright Office policies. Specifically, humans need to make a, quote, significant contribution to all of the patent claims. AI-generated inventions are not categorically unpatentable, but they can't be listed as an inventor or a co-inventor. There must be at least one human for every patent claim that does both of these things: a significant contribution to the conception of the invention, and this means the formation in the mind of a definite and permanent idea of the complete and operative invention. A human has to do this. If a human doesn't do that step, not patentable. Also, a human has to recognize and appreciate what they've discovered. So here's some examples. This guidance is under review, but these are examples by the Patent Office, and we'll see if they get sort of signed into official form. The Patent Office said that a simple prompt like create an original design for a transaxle for a model car, including a schematic and a description of the transaxle, is not patentable. Why? Because the formation of the invention was not made in the mind of a human. It was made by the AI. In contrast, it would be patentable if a biochemist designs and trains an AI system on a compound that would bind to a cancer target site that they have in mind, and they have specific requirements that they're looking for, like I want to find the best binding affinity to this target, I want something that reduces this type of harm, and they create an AI system to run those models for them. That's patentable, because the idea for the invention was formed in a human mind, not an AI mind. Last bit in our last few minutes here is trade secrets. What do you do if you can't protect your work with copyright or patent? You can use trade secrets. So if you have code that was vibe coded, you probably won't be able to get copyright protection, but you can keep it a trade secret. And it's protected against theft and misappropriation. The downside of trade secret is that it's not protected against reverse engineering or creation by somebody else. In order to maintain the secrecy, you have to make sure that you're doing NDAs, make sure that you're protecting against access with badging and things like that. So reverse engineering, not a problem. You also have to be mindful that if you're putting proprietary data into third-party AI systems, that could also risk your trade secret rights as well, because one of the requirements for trade secrets is that you use good, reasonable efforts to maintain their secrecy. We haven't seen any court cases come out on this yet, but we may see a court case saying that if you put enough information into a third-party AI system that trains on its user prompts, and that some third party could gather or reverse engineer your material based on something that it's gathering from the outputs of that, you could lose your trade secret protection. All right, so big takeaways. Copyright, we're going to be seeing billions of dollars of damages. And also, if you're a user of AI systems, be mindful that you could be risking your or your client's intellectual property rights by using AI. This applies both in the copyright and the patent space. You can fall back on trade secret protection when you can't find copyright or patent protection. Right of publicity varies from state to state, but I think we're going to get more federal law to help consolidate this for the case of deepfakes. All right. So I'll open it up to questions in the last few minutes. And please register for my newsletter if you want to know more. It's on my website.